This is part 2 of Understanding Helpfulness for the U Visa Certification and the Ongoing Assistance Requirement, presented by the National Immigrant Women's Advocacy Project at the American University Washington College of Law. Thank you for attending. Let's get started.
What are the different ways that you all, we've been talking about helpfulness, and I thought we'd take a moment to have some of you give some illustrations of the different ways you see helpfulness in your work.
There's so many ways. I think Tara gave some really good examples just a few minutes ago. And thinking about this, a good example is, we've had several felonious assaults. I can give an example, like a shop owner that masked person came in and pulled out a gun, asked for all the money out of the register. So that individual called the police and we responded to investigate, handed over, it was an owner of the shop, handed over the videotape of the surveillance, but that's all we have. I mean, very hard to get an identity. I mean, that person was helpful in the detection of the crime, reported it, gave us all the evidence that was available to them to support that crime. And I would offer to say that person is very likely to be helpful in the future if we do make an identification. Maybe there's a string of armed robberies, without giving too many details. I mean, there's the kind of cases we get like that. So that's a really good example. And then we see a lot of domestic violence cases where this form of relief comes into play. And I think, we've heard the 911 one a couple of times, but we've had situations where 911 gets called, patrol goes out there. There's really not a whole lot of information. It might not go anywhere that evening, but on the follow-up investigation, which we routinely do, we contact the individual after. We did get some information, and the individual, although didn't really want to go forward with the case, allowed us to take some photographs of the injuries, giving us an opportunity to maybe do another follow-up with an advocate to hopefully break down some of those fears and barriers. There's no problem with me with that type of helpfulness. I think that that would work, and we sign in those on a regular basis. So I don't know if anybody else has anything different, but I feel really comfortable with those two, that maybe some folks that are viewing this might not think outside the box to say that, wait a minute, yeah, I guess even though you don't have a perpetrator, even though you don't, have a case going on, you still can sign the certification. They certainly are still helpful.
So Mike, in your example that you gave where the victim called 911 and then you said that they did ultimately later participate in follow-up investigation. Would you have would you have signed that certification even if the victim had not participated, had not followed up, had not participated in a follow-up investigation, and the prosecutor wasn't able to charge?
Really good question. I think, absent more detailed information, I mean, if I was reading the report, I think, yes. I think, like you guys already demonstrated in your conversation, you have an individual calling 911 to report that incident occurred to them. There is no, USCIS, this relief doesn't require us to have convictions, have cases ongoing. There may be a lot of really good reasons why they didn't provide us with, information we'd love to have. Obviously, I'd love to have the information to make an arrest and get a conviction for you and all that kind of stuff. But I would lean towards yes on that, absent anything that was unreasonable. I think calling 911, alerting us to the individual, telling us about the crime. Maybe they didn't let us take pictures that night, but they did in the follow-up. Maybe they didn't in the follow-up for really good reasons. So, good question. I think tough one. I think a lot of folks that are on this webinar, like listening to this and being a part of this, would kind of question it. But we can't make this harder lifting than it needs to be. We have an individual who qualifies. They were a victim of this qualifying criminal activity. They did at some point reach out to us, give us information. We're good to go. And again, I know we're getting to this part of the presentation, but absent anything that's really unreasonable, there's no reason for us not to sign that. Have no fear. USCIS has a great department that goes over all of these requests. They have a fraud department that looks into the ones that have any red flags of fraud. So we're doing our job out there to help get them the individuals they need to now take a look at their case and decide whether or not to give the relief to. So hopefully that answers that, Tara, but I feel comfortable with it, yes.
I like Judge Briel's example where the victim accesses the court system in the way that they believe they need to, reports this crime, and gets the ball rolling. And because of what they reported, law enforcement can then potentially pick up this case and get a sex offender off the street. That is exactly what this is designed to do.
Yes.
And so just that little bit of information, victims not being perfect, just trying to get help from the court system exposes this sex offender is probably victimizing lots of other people. And I think that is a great example.
Yes, I love the way you use that word, like they're not being perfect. The intent of this was to not require them to be perfect. And Leslie's in the house right now. She can talk about that, but there is no, platform there where they have to be the perfect victim and give us all the information that we need. We recognize that. God, I mean, I think about the cases that I've had over and over again where victims don't cooperate throughout the whole process for really, really valid reasons, and they're here documented. So just add that person now that is here undocumented, has all these other barriers and fears in front of them. Certainly they're more likely to not, be a part of the entire process from beginning to end than even folks that we're dealing with the same type of crimes that are here documented. So I really appreciate that you said that. And we need to start focusing on the fact that we're not going to have individuals that are meeting every single need that we may have for our quote unquote cases.
Right.
But it's not about our case, right? It's about the individual.
Right.
This is a victim-centered form of relief. It's not about Tara's convictions. It's not about, the judge putting the gavel down and the person's going to prison, or me putting the cuffs on and getting them off the streets. It's about that individual.
Right. And one of the things we're going to get to in a little bit is the whole U visa system is set up so that you certify in helpfulness, and then there's a requirement of ongoing assistance. And so the victim is encouraged to continue to provide assistance unless they can't unreasonably refuse to provide assistance. And what we find is that over time, as they get more stable, they actually do cooperate in some way or find more, so the people go back and forth because they're afraid and they're still with their perpetrator. The perpetrator is still out there. And so it was designed to give that kind of flexibility. And that ultimately they need to tell, if they didn't cooperate at some point, then they'll have to explain it to USCIS and show them as part of the whole totality of what was happening, that they deserve to get the visa. And so there's a check and balance in the system in that way that USCIS decides. So what are some of the best practices that you're seeing out there on when to certify?
I think it's a best practice for courts to have a protocol or to put on the court website what an individual should do when they're seeking a U visa certification, when they have a request for a certification, just in an effort to be transparent. An advocacy agency, a nonprofit, or a lawyer, even a government lawyer, needs to know where to go when they have a U visa certification request. And I think, Leslye, you might have included in some of the materials the protocols that San Francisco has, the U visa protocol.
Yes, on the webpage accompanying this webinar, you have the San Francisco protocol and then a model protocol that takes the San Francisco protocol and expands it to include T visas. So you have two samples. You have a real one and then a sample built off the real that are both available.
Yeah, I mean, I think that we've already demonstrated a best practice in discussions around, doing this on the front end. I mean, as soon as any of us that are certifying officials get the necessary information, the person's a victim of a qualifying criminal activity, they have been, or they are being helpful, or they're likely to be helpful in the future, that's the time to do it. And I would piggyback it with, I think, we've experienced around the country in our trainings, and I can say that, there's been a little bit of this experience in my work, in my jurisdiction, where we kind of keep it close to us. So like, if Charlotte's working a case and I'm working a case that, it's like, I should do it, you shouldn't do it, that type of stuff. Tara, you have a case that you're working on, it's going to trial, and it's way easier, obviously, to wait until the end of it, to do this for the prosecution, because a lot more work has to be done in the courtroom to overcome the fact that the defense attorney might bring up, did this person get a certification? But to revert back to that, it's not about us and our cases and me and my, the defendants I'm working to get charged. It's about that individual. We kind of step back and work together and, interact with each other, collaborate, the word we've been using a lot today. If I'm going to do it, I make sure I make sure everybody in the system knows, hey, listen, I signed this. If I didn't do it because I didn't have the information, but one of you did it, it gets back to me, so I know. So I'm doing the work with the victims, doing the follow-ups and that type of thing. So I guess that early on, as soon as you get the information with collaboration, would be the best practice for me.
So it's not required. And I've been talking about victims don't have to be perfect to qualify for this U visa. And if you think about it, think about all the work that can go into the investigation and prosecution about a case, even with a cooperative victim, and still not getting a great outcome. And so why would we want to put this pressure on victims who are seeking relief under the U visa? And so it would then take away that feeling of trust that victims have with the court system. And so, looking at this list, not going to require that a conviction happens, that charges get filed, that someone is arrested or identified, or even that the offender's alive. If you think about this, these are all things, for the most part, that are out of a victim's control. These are things that the court system, the process, the defendant's control. And so when you think about that victim-centered approach, taking our victims where they are, accepting what it is that they're able to give us to just keep that ball rolling is really all that this process requires.
So why would you want to sign a certification for someone who hadn't been subpoenaed and send this to Tara and Charlotte?
Well, I think for all the reasons that we've talked about earlier is better for victims. Whether it's kind of irrelevant whether we've already subpoenaed or plan to subpoena or don't plan to subpoena a victim. Frankly, if you hold a signing a certification over a victim's head, and it's dependent on her testifying or showing up for court is dependent on, you won't sign it unless she does so. Besides the fact that it's horribly manipulative and not victim-centered, it's likely to backfire on you. If a defense were to get wind of that, and you have to be honest in what you're receiving from victims and things that victims are saying about the case, that actually makes your case, it's probably potentially more harmful for your case than if you just go ahead and certify it.
I would say, if you think about number one, if you're going to do an evidence-based prosecution, which is the gold standard for prosecuting intimate partner violence, you're not necessarily going to use that victim's testimony anyway. And so you would not, why would you have the certification depend on your trial tactics and your trial strategy? It might be not safe for that victim to testify, but you can still make your case. Does that mean because they reported a crime, you shouldn't certify? That's not the right thing to do. And so there might even be other trial reasons that you don't have a victim testify or subpoena them. You may look at your order of proof and say, I really don't need my victim's testimony to prove, or this particular witness's testimony to prove this kidnapping case of another person, but they were still helpful. And so if you look at it from that perspective, it's because following through with your promises is the right thing to do.
Well, and another example that you reminded me of, Charla, is you could have a case where it's a domestic violence case. She comes forward and files a police report of domestic violence against her boyfriend, who's a drug trafficker. And you, as a prosecutor, you're the drug trafficking prosecutor, right? You don't really care about the domestic violence. You just want to prosecute that drug traffic. And she's your star witness. So she comes forward, you could certify the domestic violence, and because she got a certification in the domestic violence, she's a much better star witness in your drug prosecution. And so that example is actually, I believe, in the preamble to the regulations on the U visa as an example of, it's not about the crime you're prosecuting, it's about the crime she's coming forward to tell you about. So, so the next question I have to kind of, and you, Tara and Charlie, you've been hinting about this just for the prosecutors on the call. I think it's really important for them to understand how this can fit in to successful prosecution strategies. So could you spend a few minutes talking about, how this might, under what circumstances certifying a U visa could actually lead to getting in prior consistent state?
I think we know that the reality is that often we do. Yes, evidence-based prosecution is the gold standard. Well, I don't like that term because all prosecution is evidence-based, right? At the same time, the reality is, especially in the misdemeanor world, where our injuries are less severe, we may have less history to lean on. The reality is that sometimes victim testimony is needed. And so when you are looking at considering a certification, or when you've signed a certification and you're at trial and you're worried about it, because very often I hear from victims or from prosecutors who are worried about what impact this is going to have on their trial. And we actually have some recent case law in Minnesota that addressed this very thing, where the defense wanted to bring in the fact that, well, they didn't know. It was essentially a fishing expedition, but they were wanting to bring in the fact that the victim was eligible for a U visa. And the Court of Appeals really focused on the timing. And I think that's what we can do as prosecutors, is focus on the timing of when the victim actually learned of that remedy. When did they seek that certification? When did they even know? And 90% of the time, most often, it's going to be when they reported that crime having happened to them, they didn't know that they were eligible for a U visa. They hadn't applied for a U visa. And so that's an important thing. We can make a motion for an in-camera review if you have a situation where a victim has applied, and the judge can look at all of the evidence. Because often what I'm seeing is that defense attorneys, what they really want is to get in the fact, into evidence, the fact that the victim is undocumented, because it can be highly prejudicial with a jury. And I think we really have to work hard on making sure that the judge understands that that's not relevant, that we make motions in limine that excludes not only the fact that they've applied or know about a U visa, but the fact just that they're undocumented.
That is similar to the law in Georgia, and we do follow the federal rules of evidence, and we want to do that 401, 403, 401, 403 balancing. Is it relevant? And then does the prejudicial impact of this information outweigh the probative value? And when you're looking at a victim's immigration status, what Georgia courts look at is there a probative connection between their status and their use of the U visa and the actual crime? And so domestic violence, if you're looking at that pattern of violence, that pattern of power and control, the fact that the victim is undocumented is absolutely not relevant, and we would want to use a motion in limine to keep that out. And then also, do the defendant know whether or not this immigration process existed? They, choose this victim because they would be eligible for this.
And the one thing I just want to add, because there are situations where you may have signed and now it is in fact relevant. There are situations where a court may actually allow it in. However, it's important to get clarification from the court. And again, I think doing it as a motion in limine is much more helpful than having it happen during trial. But that then opens the door to a lot of if the court is going to allow testimony about the U visa, that the victim sought a U visa, again, you're going to talk about the timing of that, but you're also then going to make clear to the court, and I've seen courts allow this, that then that opens the door to a lot of a prior history of domestic violence that may have not otherwise come in, because you can actually end up using it as a tool against the defendant.
Yep. You could definitely use it. I was going to say, just using the fact, I mean, even think about all the things that we've talked about with the certification process and all the things that the DHS does to identify and vet these applications. And you would just use that as part of your case to help to prove the fact that actually to help corroborate your victim's story and to corroborate that coercive control. And so I think you would just use the thing that you might be afraid of and use it to help prove your case and then to strengthen your case.
And let me
I think from a judge's point of view, bringing up the immigration status of a victim also then suddenly brings up the immigration status of a defendant. And it really dirties the waters and prejudices the jury, perhaps against the defendant. And there's, a multitude of reasons why in a motion in limine, that information should be kept from a jury.
We had a recent case, a Supreme Court case in Georgia, not involving an undocumented victim, but the court excluded that prejudicial evidence and was upheld. And so be happy to share that if anyone needs it.
And it's really important to understand, we have whole other webinars on this, but the fact that, this U visa issue is coming up, some perpetrators will try to, and this comes up in family court cases and criminal cases, they'll try to get a copy of the U visa file through the state court system. And the long and short of it is that the only thing that's discoverable would be a U visa cert signed by a judge, a police, or a prosecutor. The cert itself, nothing else. So we have there's a whole bunch of law, and there's some really good law about relevance of immigration status as well that you should know about. But that's a whole other webinar that we can connect you with.
And to the point of the slide here too, that is a prior consistent statement by the victim. So another way it can be helpful.
Okay, right here, we just have a nice little chart that gives you the flow of analyzing these requests that we receive. You're looking at the criminal activity, which one do you have, identifying any victim or indirect victims who may be a part of the criminal activity. We're looking at what we just talked about, the helpfulness of that person. Are there any family members that are implicated in the crime? And then, like we mentioned earlier, noting any injuries observed or any information we have that we can provide to check that last box around that injuries. So why don't we go to the next slide? So everyone, what would you look for in deciding whether to certify? What are the key things based on your discipline that you're looking for?
Well, for me, I'm looking at any credible evidence. And as I think you mentioned before, Mike, I want to list all qualifying crimes. I want to look for all qualifying crimes and list them when I'm deciding to certify.
Anyone else?
Basically, that victim did enough to establish that the qualifying crime occurred and to get the ball rolling.
Yeah, I'm looking at what criminal activities I can, check off. I'm looking to see, if there's any other information like the injuries we talked about and any other victims. And, we've had numerous cases where one request and the investigation that followed that request turned into, like Leslye mentioned earlier, numerous victims and numerous U visa certifications signed and a couple of really bad individuals off the streets.
Judge Brill, what about victims with criminal histories?
Well, it doesn't matter to me when I'm looking to sign a U visa certification request. I don't think it's relevant. correct me if I'm wrong, because I'm happy to take guidance from my experts on my colleagues on the panel here.
Well, the main thing is that criminal history, there's no bar, like U visas. If you have a criminal history, you're not barred from the U visa. DHS will look at your criminal history and look at the whole context of the abuse and decide whether they want to give you a visa despite your criminal history. They have to essentially waive your criminal history in order to grant you the visa. So that's going to be something, like Mike mentioned earlier, that USCIS is going to fully adjudicate. So, and go ahead.
Sorry. That could be really helpful, for example, in gang cases where there's human trafficking or some other crime associated with it. We want everyone to understand that those victims are not precluded from this relief.
Exactly right. And USCIS will look at the connection between the crime and the victimization as one of the things they look at when they decide whether to grant somebody who's been a cooperating witness in some way or come forward and provided helpfulness and maybe ongoing assistance, but has a criminal history.
Yeah, I'm assuming it could affect their good moral character with USCIS, but many victims, especially victims of human trafficking, do have long criminal records, or were charged with prostitution before it became outlawed in certain states. So,
Exactly.
and as Charlotte, as you pointed out, gang victims, they may have criminal histories. For me as a judge, it's not relevant to my findings.
And when we think about domestic violence being one of the big motivators behind the U visa, for example, you have domestic violence victims who don't speak English. Police arrived on the scene, didn't use qualified interpreters, arrested both of them, and then they took a plea. And so we knew that was, and that's why we wanted to be sure that DHS had the discretion to waive, for example, that plea that a domestic violence victim who was not a perpetrator of the abuse in the relationship at all, but took the plea anyway. And those things can happen. And so what I want to do now is move on for a second and just give you a little bit of information about so if you're talking about victim-centered approach and keeping victims safe, one of the things that's important that everybody on the webinar knows is that one of the reasons it's very important to sign U visas certifications as early as possible is that it puts the victim's case, when she files it or he files it, in a computer system at DHS that red flags the case. So if the rapist or the trafficker or the domestic violence perpetrator calls up DHS to try to turn in the victim so they don't show up in Judge Briel's court on the protection order day, or they don't show up in Tara's prosecution because they disappear, they get picked up. This system is designed to keep DHS officials from responding to tips from the perpetrators. But if the victim isn't identified and there's not an earlier certification, you essentially lose that protection in your criminal cases or your criminal investigations. So it's part of the victim-centered approach, and it's important to know how that works. And then there's, basically, as we said, there's a continuing obligation once the victim files and is based on the certification of helpfulness, she then files. There's a long process through which the victim has to go, where there's background checks, fingerprint checks all along the way before giving a bona fide determination, before the case is approved, and before the victim gets lawful permanent residency. And at all those different points in time, they're going to look at background checks, and they're going to be asking her about whether she was continuing to assist if reasonably requested to do so by a police or prosecutor. So why might you want to sign a certification for a crime victim when the crime happened 20 years ago?
Well, I think the easy answer is that there's no statute of limitations. So why would you not sign simply because it's older?
Well, I think there's also a lot of, these older cases, the information's just getting out there in the community, and it's maybe it's most likely as a result of the good work that's being done in the jurisdiction. And next thing you know, someone comes forward from something from 8, 9, 10 years ago, whatever, 20, whatever you want to call it. And we uncover, additional victims, maybe even additional perpetrators. And, we're getting eyes on some real violent offenders that we wouldn't normally. So, and it's the intent of the law, right? There's no statute of limitations. So why wouldn't we? Like you said, Tara.
Right.
In my
And
experience, go ahead, sorry.
with our improved technology with DNA and other forensic sciences, we are able to solve crimes we weren't able to solve 20 years ago. And so we are actually going to find victims that may have, thought their cases would never be solved. And so they should also be included in that process.
And then finally, I would add that the fact is that not everyone in the community knows about these remedies. So it's very possible that a victim may not know that they had this option available to them 20 years ago. I know I can speak from my own office. We've improved vastly on our ability to flag this issue for victims and get this information to victims. But not every community is as good about spreading the word on this as others.
So I know, Leslye, you've done a lot of research about whether U visas are effective in promoting access to justice. And I'm wondering if you can talk just a little bit about what research tells us.
Yeah, sure. We have a report that was published in, we have several reports over the years that we've worked on from 2012 and the most recent one in 2021. And essentially, as I mentioned a little bit earlier, what we find that once a victim file, when agencies sign UNT visas, we see like a 70% increase in the victims willing to call police. We see a 67% increase in victims' willingness to seek protection orders, and a 64% increase in victims' willingness to go to court and seek custody. So it really does, how would I put this? We're talking about building trust. We've been able to document how well this works as a tool to build the confidence of undocumented and documented immigrant survivors in the justice system. And then what we did is we also looked, and this is our most recent research, 2021, we found that when, once victims file the case and the case progresses to the point where they're getting work authorization and real formal protection from deportation, they've had something where basically DHS is saying, we believe you, where they've gotten a piece of paper back that gives them more stability. We see 114% increase in the willingness to trust the police. 36% make police reports regarding future crimes. This is not the case they're involved in. This is things that happen in the future. 22% of that other victims help other victims report abuse and seek justice. So they go and talk to their friends and their sisters and their mothers and their cousins, and they encourage them to come forward. And importantly, we see a 67% decline in immigration-related abuse and in the unwillingness to participate in prosecutions, or in dropping in victims who say they're not willing to participate.
Leslye, you said something really compelling when you were talking about the impact for victims of being believed by the system. So many victims are afraid to come forward because they're not going to be believed. And so I could see how it contributes to the increased statistics.
Right. Having that piece of paper from DHS saying, we give you a bona fide determination, we give you a prima facie determination. It's like, wow. That especially, it's like, to some immigrants, it's the most feared group, right? And they've taken this risk and they've gotten a positive response. And we also, and so what happens is we also see significant reductions in abusers using this immigration-related power and control tool. They stop. We see a decline in immigration-related abuse, We see a decline in threats to snatch the children. And courts, judges report to us that they see a decline in family court perpetrators trying to use immigration status against the victim in the divorce or the custody or the child support case. So it all, I think you're right, Charla. A lot of it is the confidence that builds in the victim as she begins to feel like the system's going to believe her. And she begins to trust the system and the victim advocates and attorneys who are supporting her through the process of, because immigrant victims don't file these cases without the support of victim advocates and attorneys. And so their role is also important. So now we're going to switch over. We've been alluding to this, but dig in a little bit more on this whole issue of ongoing assistance. Like once she files, once you've certified and she files, what are the ongoing assistance requirements? And so she has an obligation to provide continuing assistance when reasonably requested by law enforcement and prosecutors, from filing all the way through the point of when the victim gets lawful permanent residency. What happens after signing a U visa certification? How does it promote victim? How have you seen in your cases that it promotes victim participation in the system?
I think it's exactly what you found in your study, Leslye. I'm seeing a decline in a perpetrator using immigration status to gain an advantage over a victim. I'm seeing victims have a lot more courage, especially if I issue a move-out order, but still order the perpetrator to pay for the, the rent of the victim. I think that there is less coercive controlling behavior, exactly what the studies have shown. And of course, participation in the system.
The trust in the system in general, and I can speak for my profession. I think that especially when we're collaborating, we're all working together and doing our thing, and they're seeing, some of the light at the end of the tunnel with some of the, resources that are available. We see a lot more trust in the work we're doing in the system, and they stay on board. It really just helps everything, all of us, all the work we do.
So Mike, can you walk people through kind of how helpfulness is different than like the ongoing cooperation assistance that we're, the ongoing cooperation?
Yeah. So, when you decided to sign the certification, so you're getting that information that you need before you do that. It's what I talked about earlier, where, have they been helpful, or are they being helpful, or do you think they're likely to be helpful in the future if you do get the information that you need in the detection or the investigation, prosecution, conviction, or sentencing? So it's any of those things. After the filing of the U visa, and then for permanent residency, they have an ongoing obligation to provide cooperation or assistance. Anything that's reasonably requested by law enforcement, prosecutors, there's that obligation to provide that. And there is an exception, and we've kind of, skirted around this a little bit, talked a little bit about it, but they can show that if their refusal to cooperate or assist, was not unreasonable, that would be an exception. So there's a lot of ways that can happen. It's very similar to when I'm looking at the information to decide to certify. I mean, these crimes, again, take a look at that list. It's going to be very obvious to everyone that does this work. There's very, very valid good reasons why victims of those particular crimes may not provide us with that cooperation or assistance. So don't lose sight of that. But there definitely is a little bit of an elevated obligation there once that has been filed, and or the permanent residency as well.
So what's the analysis, Mike? What are the two questions you're trying to figure out here?
So we have here up in the slide, is the request reasonable? If the request is reasonable, if the refusal is unreasonable, that makes a big difference. I'm not going to go there. If the refusal is unreasonable, then that's going to change the whole dynamic, and it's going to change what this law was put in place for. So I'm looking at this request. Is it reasonable what I'm asking them to do? And is their refusal to do that either reasonable or unreasonable? And that's the access point where I'm gonna go the left or right in my determination. That makes sense to you, Leslye?
Yeah, so
Sometimes my examples get really, I'm visual with it. So unreasonable requests, consider if the request endangers anybody. Is it endangering the victim, witnesses, family members, other people involved in the case, other people who may have been present or have information? Does it put that person in greater harm, if they do respond to your request? Does it increase trauma to the person? Does it affect the victim's ability to support themselves or their family? Is it reasonable in light of the perpetrator's force, fraud, or coercion of the victim? And again, I really encourage you to take a look at the crime and, without anything else clouding that, think about all the reasonable reasons why that person might have a reluctance to provide some of the things we may wish they did, I guess. To the easy way.
legitimately for their own safety reasons.
Right. So the next one,
Go ahead.
statutory and regulatory exception. I don't know if you wanted to go over that.
Yeah, I can
Leslye?
do it. So basically, because of the things you're talking about, Mike, when we wrote the statute, we understood that there would be times then that the victim's choice not to cooperate wasn't unreasonable. They were protecting their safety. The perpetrator locked them in the house and didn't let them out. The perpetrator, fed the subpoena to the dog and she never got it when, she didn't even know she was supposed to be there. I mean, there's all these things that could have happened. And so what they said is, has the victim, they created an exception so that when the victim, as long as the victim did not unreasonably refuse to cooperate, they can get their U visa. They can get their lawful permanent residency. And that's the exception. They have an ongoing responsibility to cooperate, but they cannot unreasonably refuse to do so. And I have to personally apologize for all those double negatives because I helped write them, unfortunately. So I even get tongue-tied with them. So Tara, tell us a little bit about kind of some of the reasonable refusals you see.
Sure. So I think when we're making this analysis or answering these questions, it's just really important for us as certifiers to keep in mind, top of mind, all of what we know and what the research tells us about the dynamics of domestic violence, the dynamics of victimization in general, and what we know about how people respond to trauma and victimization. So ask yourself, is it reasonable to request for a victim to refuse a request if they're in danger? Is it reasonable if they didn't even know about the request? That's, of course, an easier one. Did we have a good address to send a subpoena to? Did we actually have good contact information? If a letter came back to us, is it reasonable for us to consider that as an unreasonable refusal? We know that in domestic violence and intimate partner violence and sexual assault cases, intimidation is near universal. We know that the only time that we're hearing about it is if it's not successful. So the reality is that almost all of the victims in our cases are being intimidated in some way. And I think what the harder one is when victims maybe aren't being threatened and intimidated, but are being manipulated. A much more subtle tactic that's used by perpetrators, but very, very effective and powerful. And again, given what we know about the dynamics of these relationships and the power that perpetrators have over their victims, it is reasonable if a victim is being manipulated for her to then refuse further requests by our office. Is it reasonable for a victim to refuse to participate in an investigation or a prosecution? And I shy away from using the word cooperate because it has this ring of that if you don't do it, it's something that you were supposed to do. Instead, we use that they're willing or able to participate. So again, we consider this broadly. We have to consider helpfulness broadly. And if at any point they were helpful, and if we think any of these things on this slide could be a factor, we can consider it a reasonable refusal. The DHS, it's important for you as a certifier to consider the totality of the circumstances and apply what you know, as I said, what you know about trauma and the nature of victimization to this analysis. Consider the victim's fear of the perpetrator. Consider any possible intimidation. Consider, it's also, it's right there in the regulation. We are allowed to consider the age, maturity, and capacity of the applicant in deciding if their request was reasonable, or if their refusal to abide by a request was reasonable. If a 15-year-old victim who is being assaulted by her family member, and that's their only home, is it reasonable that they would not be willing to testify in a trial? These are things that happen every day in our cases, and that we absolutely have to consider when we're making this analysis. So I'll pose this to the rest of the group. Why would a victim report a crime and then later refuse to participate in the ensuing investigation, prosecution, trial, or court case?
So I'll start. A lot of times for a lot of victims, reporting a crime can make them feel more unsafe. And particularly in intimate partner violence, reporting the crime doesn't always end the course of control. It can make it more extreme. And that creates a barrier to a victim for participating. And then, unlike cases where a victim may not be intimately connected with the perpetrator, victims experience real life consequences because of what happens in the court system. And I think a lot of victims do those calculations and think about the impact of what participating in the court process is going to look like. And if you're undocumented and you think you're going to face deportation or separation from your children, not a different equation to figure out why victims would not want to participate.
And as you said, Charlotte, we know that as the prosecution advances, it becomes highly dangerous for victims. But not only are they subjected to threats and manipulation and fear of what might happen, there's also other real factors that come in, that may come into play, financial implications that aren't a threat, but definitely an important thing in their life, or childcare issues. There's all kinds of things.
Culture. You come from a culture where you don't talk
Absolutely.
about intimate partner violence outside of your community, and you get pressure from your community not to participate. There's so many reasons.
And the reality is, just the mere fact that reported it most often puts them in more danger. These aren't, again, the shoplifters, larceny individuals. These are some of the most violent criminals in our communities. And when you have, a victim come forward and report to us, it, inherently, majority of the time puts them in more danger. And we need to support them and keep them, safe, and recognize the fact that they may not. They may give us all the information we want at the patrol officers. The next day when I call them up and want to go talk to them, they slam the door in my face because, the person that got arrested's best friends, who are also gang members, said, you go to court, you go to the arraignment, you testify, we're going to kill your family. We're going to find your family in the country that you're from. We're going to kill your family that's in the country that you're in, that type of thing.
What did Tony Soprano say? No victim, no crime.
Exactly.
Witness, no crime.
Yep.
And that's what people are, snitches get stitches. And that's what people outside the court system believe. And so we have to think about that and think about the impact of witness intimidation. Speaking of witness intimidation, in my experience, you have to be proactive in preparing your witnesses for witness intimidation, because we know what's going to happen, and talk to them about what it looks like, how to document it, what they should do if it happens, who they should call, et cetera, et cetera. And then as public service, public safety professionals, we have to keep our promises. We say the court system is going to make people safe. We cannot allow people to intimidate our victims or witnesses by not following through on bond revocations, bringing witness intimidation through the court, seeking protective orders on the Crime Victims Bill of Rights if those are available, and working with our advocates to keep our victims close, to check in on them, make sure that their needs are taken care of so that they have that relationship, that trust with us that allows them to feel safe telling us when intimidation takes place. Jail calls, when they're available, if the perpetrator is not released on bond, are really important for identifying witness intimidation, but also listening to understand those dynamics between the perpetrator and the victim so that you can see how the intimidation takes place. Want to have great relationships and great communications with the victim's immigration attorney or their community-based victim advocate if you're a prosecutor. And then we want to work with our victims to create safety plans for our victims so that they can have those safe points of contact or safe places to go. Understand those power and control dynamics. And one other good thing, one thing that we do is when we create that safety plan with a victim advocate, if possible, incorporating some of those requirements into if there's a bond or any other boundaries that the court places on the defendant, incorporating those elements of the safety plan into those legal documents, if it's a bond or a civil protective order.
So after all that, everything we discussed, if you still think the person is unreasonably refusing, it doesn't mean you can't sign the certification. It's very easy for us on the outside, to be saying, they should be able to give me that. That shouldn't be a problem giving me that. But we aren't in their shoes. We don't know what some of these barriers, fears, some of these, intimidation things that are going on are. So it's okay if you don't have, if it's not meeting what you thought it should, it's okay to note that on the certification. You can still sign it and return it to USCIS. The burden's going to shift to the victim to show them that their refusal to provide whatever it was we asked for wasn't unreasonable. And they're going to give them an opportunity to do that. And ultimately, they're going to make the decision. So I guess the message is it's okay. You can still sign it, put a note on there. The next slide is going to show the actual box on the certification. It's okay to check yes on that and put some notes on the reason why. But they are going to give that person the opportunity to at least give them the information as to why they don't think that was unreasonable to not provide that to you. Hopefully that makes sense to everybody. I guess we're about opening doors with this. I mean, our role is opening those doors, absent something clear as day to close that door, and let USCIS do their job. They're there for that. That's their role. They recognize that. A few of us on the team have been out there to train up at their offices. We trained them, they trained us and gave us the information that we needed from them to go out there and just assure everyone that they take it seriously. They have the special individuals that look at these cases and their fraud department and such, and just know that they're going to do the job that needs to be done to not let things fall through the cracks.
Well, thank you to all of our faculty today and to NCJFCJ for hosting this. I'm going to conclude this webinar by telling you about some of the resources that are available. So we at NewApp offer technical assistance to all of you who are working on this. Our faculty are all part of our technical assistance team. So if you're a prosecutor and you want to talk to a prosecutor, we can put you in touch with Charla or Tara or one of the other prosecution team. If you're a law enforcement officer and you have questions about this, we can put you in touch with Mike or some of the other law enforcement officers, and Judge Briel and other judges are available to provide technical assistance to judges. For law enforcement and prosecutors and victim witness staff listening to this call who work at law enforcement prosecution offices, we invite you to join. We have a community of practice that it's a roundtables that we hold every other month approximately, led by Mike and Jean Anderson from Equitas. and many of the faculty that you saw today might also join those calls. So we encourage you, if you're interested in joining, becoming part of those roundtables, send an email to the email address on the slide, and we can get you signed up if you work for law enforcement prosecution agency. If you're a judge and you're hearing this webinar, we also have a peer-to-peer network of judges. You can send an email as to the same address, and we can get you signed up for that judge-to-judge peer-to-peer sessions. And if you're a victim advocate or a family lawyer, we have communities of practice in those fields as well. So please do email us if you're interested in joining one of those communities of practice. There are resource tools, a U-Visa certification and T-Visa certification toolkit that we'll distribute as well, along with most up-to-date DHS policies and procedures in the area of U-Visa certification. So in closing, I just want to thank all of the faculty for all your great work on this, and thank all of you who are listening for all the work that you're doing in the field to assist crime victims and immigrant victims. And again, thanks to FCJ for hosting us, and Brianne Smith in particular for her help with this recording. Thank you so much. Any last statements from faculty?
Thank you.
Thanks, everyone. Stay safe.
Thank you. Keep fighting for our victims.